Good afternoon. Welcome to our webinar today. My name is Kim Stanger. I'm the head of our firm's health law group, and we do periodic webinars on a monthly basis to advise our clients of different health law issues that are coming up. As I was thinking about this month's webinar, I thought, well, it's the new year. Let's talk about some of the compliance issues that you who are compliance professionals out there need to be concerned about. A lot of these compliance issues are things that I've seen that my clients have been dealing with recently. And so I thought I would go through essentially my top 20 items that I think that you as compliance professionals ought to be paying attention to. Bit of a disclaimer, this is a brief program that's designed only to flag these issues. We're not going to go into them at the great depth, but I just wanted to make sure that these were on your radar. In addition, the application of the law will depend upon the facts of the particular case, including, what kind of provider you are, what jurisdiction you're in, whether we're talking about federal or state law or the like. So just remember that when it comes time to actually reviewing or applying the laws to your particular case, you need to look at the facts and the law that's relevant to your particular jurisdiction. With that said, let's launch into it. I think the biggest compliance risk out there right now is cybersecurity. You may not think that that's so much a compliance issue, but yeah, in fact it is. Obviously HIPAA requires you to maintain a secure environment in order to comply with the security rules. It can also result in privacy rule violations if there's a cyber breach. In addition, it's been interesting under the FTC has gotten on the cybersecurity bandwagon. As you may know, the FTC enforces the federal statute that prohibits unfair or deceptive acts affecting commerce. And the FTC has been relatively active in going after entities that have had significant privacy breaches under two theories. That statute prohibits unfair or deceptive practices. The government has said, well, if you're out there making misrepresentations in your privacy practices or your privacy policies to the public and you don't live up to those, then you're engaging in deceptive trade practices and could subject yourself to liability. In addition, to the extent that you fail to put in place inadequate security measures, that's an unfair practice, and therefore they may come after you for those things. So we're not only worried about HIPAA, but also the Federal Trade Commission Act and other laws. As you know, a lot of states are enacting their own privacy laws, so you've got to comply with those that may apply. The thing that concerns me most about cybersecurity when it comes to compliance, this is not one of those situations where, you're liable if the government catches you. If you fail to comply with cybersecurity protections to put those things in place, then the criminals are going to catch you. It's not just the government coming after you, but it's others, and you're going to suffer significant downtime, significant costs. It could submarine your whole operation. So it's really important that you maintain the cybersecurity protection. It's so important that HHS and the government has published a bunch of bulletins and guides for particularly the healthcare industry. Late last year, HHS published its guide for cybersecurity preparedness. If you haven't looked at that yet, I would strongly encourage you to do so. In that guide, they identified the 5 greatest risks that they identified for healthcare entities in addressing cybersecurity or data privacy issues. First and foremost, not surprising, are email phishing attacks. Number 2, ransomware attacks. If you've been watching the news, that's awfully scary stuff. They usually occur because of email phishing attacks. It could be loss or theft of equipment or data that's not encrypted. You could have insider accidental or intentional data loss or attacks against the connected medical devices that may affect patient safety. Those things are all scary. In that guidance that the government has given you, they actually give you some practical steps on what you need to do in order to minimize the risk to you. So I would strongly suggest that if you haven't looked at that, again, take a look at that. Of course, all of those things should be part of your security risk assessment. If you're complying with the HIPAA security rule, it's all designed to protect against those cyber threats. So hopefully all of this links up with your security assessment under the HIPAA security rule, and we'll talk a little bit more about that later. Next, sorry about that. Here's the website that has that cybersecurity guidance that's from HHS, and they've got different guides depending upon the size and complexity of your particular organization. Next are false claims. That's kind of a big ticket item when it comes to compliance issues. The law, of course, False Claims Act, says you cannot knowingly submit a false claim for payment to the federal government. And that's not only submitting the claim, but if you submit a claim and receive an overpayment when you knew you shouldn't have gotten an overpayment, then you have an affirmative obligation to report and repay the money to the government within the later of 60 days after discovery or the date the cost report is due if you're paid on a cost reporting basis. That's the federal claim. Most state laws, I think all states as far as I know, have their own version of the State False Claims Act that apply to at least Medicaid payments. Well, what are some of the risks that you need to be concerned about? Well, certainly billing errors, including any kind of miscoding, whether it's upcoding, unbundling, or whatever. Maybe it's situations where you're billing for services that were not provided as they were claimed to be provided, medically unnecessary services, services that were substandard care. The government only pays for medically necessary and appropriate care. If you're providing substandard care, then that could give rise to a False Claims Act violation. Services by unlicensed or unprivileged providers. The government generally only pays for those services that are actually provided by licensed professionals. We'll talk more about that in just a second. Maybe you don't have sufficient documentation to support the claim, and the government requires that you have the documentation. If you don't, then that could be a false claim. Maybe the services were not provided with adequate physician supervision. Lots and lots of other ways that billing errors can arise. In addition, it may be that you can submit a false claim if you fail to comply with the material conditions of payment. If the government has said, hey, we'll only pay if you satisfy these conditions, and if you fail to satisfy those conditions, then when you're submitting that claim to the government, you're certifying that you're complying with those conditions. And if you fail to do it, then the government said that that is a violation of the False Claims Act if it is a material condition. Along those lines, if you fail to comply with the fraud and abuse laws, the government has said, hey, that is a violation of the False Claims Act, and therefore the government can come after you against the false claim. You have an affirmative obligation to report and repay monies that you've received from referrals or otherwise in violation of STARC, the anti-kickback statute, the civil monetary penalties, and the like. As I mentioned, in the wake of the Affordable Care Act, the False Claims Act requires you to affirmatively self-report and repay those overpayments. So if you got money that you shouldn't have gotten, then you've got this affirmative obligation to report and repay. If you don't do that within the 60-day time period, then that failure to repay turns into a false claim, and you can be held liable for the additional penalties that are associated with that. By the way, those penalties were doubled and sometimes tripled over the last couple of years. And so now the penalties are about $11,000 up to about $23,000 per claim that was submitted. That's per claim that you submit. That's not kind of this one mistake. It's per claim you submit. In addition, you can get hit up with treble damages. And you have the report and repay obligation, just a whole bunch of bad stuff. So you need to make sure that you stay on top and avoid the false claims. How do you do that? Well, that brings us to number 3. Auditing and monitoring. In the HHS repayment rule, the government made it clear that providers are expected to implement proactive compliance activities. You can't simply stick your head in the sand, and if what you don't know can actually come back and hurt you. You're expected to implement proactive compliance activities to monitor for the receipt of overpayments. Under the Supplemental Compliance Program guidance for hospitals, the government affirmed that providers should develop detailed annual audit plans designed to minimize the risks associated with improper claims and billing practices. To violate the False Claims Act, it's a know or should have known standard. So even if you didn't affirmatively actually know that there was a problem, if you should have known that there was a repayment obligation or you were submitting false claims and you should have known, then you can still be liable under the False Claims Act. In the guidance that came out with the repayment rule, they made it clear that that should know includes that if it would have been discovered through appropriate auditing and monitoring, then you could be held liable for that knowledge. Well, I don't pretend to be a billing and coding expert, nor do I pretend to advise you concerning exactly what kind of auditing or monitoring you need, The government hasn't been that specific, but they have been given some help when it comes to auditing and monitoring in their OIG compliance program guidance. The OIGs publish these periodic guidance concerning compliance plans. They've got one for physicians, one for hospitals, nursing facilities, hospices, home health agencies, and others. I'd suggest that you, if you haven't looked at those recently, call those up for your particular provider type, your segment, and then take a look at that. And it will give you guidance concerning not only the types of issues that you should be looking for when you're doing the auditing and monitoring, but also give you some guidance concerning how that auditing and monitoring should work. In addition to, as part of that auditing and monitoring, make sure that you're watching for anomalies. If you suddenly find out that you've seen a dramatic increase in your reimbursement that's unexplained, maybe that's because you're coding improperly. One of the benefits of doing the auditing and monitoring, this isn't only to just find mistakes you've made that could come back and haunt you. It can also help you actually improve your revenue. I don't know about you guys, but about half the time when we go into doing an auditing and monitoring of the billing practices, we find out that the entity has actually been undercoding, and they can actually improve their revenues by appropriate auditing and monitoring. So that's number 3. Number 4, credentialing, licensing, and background checks. Generally, the government has said, as you may know, that you cannot hire, contract with, or submit claims for items or services that were ordered or furnished by a person excluded from the federal health care program. So you can't even employ them hire them as an employee if any of the federal money is going to make its way into that excluded individual's paycheck. If you do that, then you yourself can be hit up with penalties and also exclusion from yourself. It's not only that, though. You not only have to worry about the excluded provider list, you need to be concerned about whether or not this person's licensed, because the general rule is Medicare and Medicaid, they won't pay for services that are provided by unlicensed personnel. In addition, recently, over the last few years, prompted by federal mandates, states impose certain background requirements for a lot of providers, especially in the long-term care industry. And if you fail to comply with those background requirements, then you can be held up for different types of penalties. In addition, payer contracts generally require, credentialing. If you didn't get the provider credentialed and you submit the claim improperly, then you could be liable either under the federal statutes, if it's a government payer, or maybe under state fraud statutes or breach of contract claims. So what are some risks there? Well, obviously, hiring or contracted with an excluded individual. How do you determine that? Well, you need to check that list of excluded individuals and entities on the OIG's website. They update that approximately once a month, so you should be doing that on a periodic basis. The government hasn't said that you must do that on a monthly basis, but you would probably, to minimize your risk, want to do it on a fairly consistent periodic basis. You'd ought to have a process in place that you're checking your employees, your significant contractors, your medical staff members, not only at the time of employment, but periodically thereafter against that excluded provider list. You can't submit a claim for services that were provided by an excluded person if you knew or should have known that they were excluded. You generally can't submit claims for unlicensed persons, and that arises quite often that I see in the situations I have to deal with, or where somebody lets their license lapse. They were licensed, but they just didn't pay their renewal fees or something like that, and next thing you know, their license is lapsed, and you've been submitting claims, whether it's a nurse, whether it's a physician, and now what do? You haven't complied with the conditions for payment, so there may be a repayment obligation. There could be situations if you don't, if the services are provided by persons without, and you're a hospital, of persons without, who haven't been properly credentialed at the facility. The conditions of participation generally require that the services be provided by credentialed persons at the facility. If you haven't, if you let their medical staff membership or privileges lapse, then that could create some potential problems. To get around some of these situations, sometimes you'll have, when new providers come on board, they haven't been credentialed, or they haven't got time to get credentialed yet. Sometimes providers will try to come up with other ways to submit claims for services that new person is providing, maybe by using the NPI of another person. Well, that's a false claim unless you can satisfy like the locum tenens rule. But the locum tenens rule, it only applies in certain limited circumstances. So be careful about submitting claims under the wrong NPI because that could be a false claim. Next item, beware of changes in your provider status or operations. It's kind of a new one that's come up over the last year or two where the government has gone after people for failing to update their enrollment information. If you have changes in your operations or practices, it may not only violate the rules that require you to update your enrollment information, but it also may adversely affect your favorable reimbursement status. For example, if you open up a new facility, that could jeopardize your cost status, or it could jeopardize your 340B participation. So as compliance professionals, you kind of need to monitor what's going on in the organization and evaluate whether or not new service lines, new facilities, new providers, whether that's a change of ownership, whether that's going to trigger some kind of obligations to modify or update your enrollment, or may adversely affect your ability to get reimbursement under other programs. Next are patient inducements. This should come as no surprise to you. The anti-kickback statute generally prohibits offering inducements, including inducements to patients, unless you can fit within a regulatory safe harbor. In addition, the Civil Monetary Penalties Law specifically prohibits you from offering remuneration to Medicare and Medicaid beneficiaries if you should know that the remuneration is likely to influence the beneficiary to order or receive items or services payable by federal or state health care programs from a particular provider. Those types of red flag situations are anytime you're offering Medicare beneficiaries less than fair market value for the services that they're getting. Maybe you're offering as part of a marketing program, maybe you're offering some kind of free items or services. You're rolling into town, you look up on the sign and you see a sign that says, hey, deliver at our facility and you'll get a year's worth of free diapers. It could be a free gift basket. It could be gift cards. It could be free supplies. Could be offering free screening exams or clinics. Hey, come in, we'll give you this free screening exam. Oh, you test positive? Well, let me direct you over to our clinic and they will take care of you for those things. It could be offering free transportation. It could be allowing patients to participate in drawings or raffles. It could be giving them some kind of a discount on their services. It could be refer a friend type rewards. Could be writing off or discounting copays or deductibles or doing insurance only billing. It could be paying premiums. Any of those situations where you are offering remuneration, something of value to your patients, particularly your Medicare and Medicaid patients, then that could potentially implicate the CMPL, the Civil Monetary Penalties Law, or the anti-kickback statute. It could also implicate state laws. Your state laws probably have similar provisions. Sometimes they apply just to Medicare and Medicaid beneficiaries, but they could also apply more broadly than that to others. Now, there are some safe harbors that the government has recognized that would allow you to provide some benefits to your Medicare and Medicaid beneficiaries, including under the Civil Monetary Penalties Law. The OIG said they won't come after you for nominal gifts, which they've defined as $15 per gift or $75 total per patient per year. In addition, if you can demonstrate financial need or failed collection efforts, then generally you're okay. There are certain exceptions under the definition of remuneration under the Civil Monetary Penalties Law that apply to certain types of specified preventative care services, which are primarily prenatal and postnatal care to a mother, and certain services that are specified in the government's handbook dealing with preventive services. There's a separate exception. It's kind of a broad one that applies to services that promote access to Medicare services and that pose a low risk of fraud or abuse. There's certain others, but for all of those safe harbors or low risk situations, there's certain common elements. Even if you don't fit within a particular safe harbor, if you structure your transaction to fit within these kind of common elements, then you're probably going to be okay. First, of course, if it's the item or services was not intended or is not likely to induce or reward a federal program business. If that's the case, then you probably don't have a breach anyway. If it's not advertised or used as a gimmick to induce the business. advertising these gifts to your patients in order to get them to come in, that's a huge red flag. So make sure that you work with your marketing people, you review what they're doing so that you have this open line of communication and suddenly don't realize that, oh my goodness, we've been offering these or advertising these free gifts to patients to come in. It can't be conditioned or otherwise tied to other items or services paid by federal programs. This was a hot ticket item, particularly under the anti-kickback analysis of these types of gifts or inducements. And of course, evaluate whether there's a low risk of utilization or interference with clinical decision making. The government's issued a special advisory bulletin that's helpful in analyzing these gifts to or other inducements to program beneficiaries. I've got the site for that up there on the screen. All right, let's talk then about, well, we're not going to give stuff to just the patients. What about to other third parties? Maybe it's the, employees or independent contractors. What about, can we offer them remuneration in order to make referrals? Well, you still got to be concerned about the anti-kickback statute. It could be the CMPL if it's offered to patients. In addition, under the opioid laws that have come out, the Support Act and others, the government issued the Eliminating Kickbacks and Recovery Act, or ECRA, which says you cannot pay remuneration for referrals to a laboratory, recovery home, or clinical treatment facility unless the arrangement fits within a regulatory safe harbor. This is broader than the anti-kickback statute. The anti-kickback statute only applies to referrals for items or services payable by federal health care programs. ECRA isn't so limited. It applies to even private pay situations, so you really have to be careful about situations if you are paying commissions to contractors. If that could violate the anti-kickback statute, the government, the OIG, issued some commentary which basically said, hey, we don't like you paying independent contractors commissions based on their referrals or the business they generate from you that's payable by federal health care programs. They said that if you want to pay those independent contractors a commission, then you'd ought to employ them as employees rather than as independent contractors. So under the anti-kickback statute, you may be able to get away with paying employees commissions, but not under ECRA. Currently, we don't have a safe harbor that would apply in that situation, which is causing a big problem in the lab industry because they like to or have historically paid salespersons commissions, and under ECRA, that appears like that could potentially be a serious violation. You have to be concerned about other types of remuneration to referral sources. It could be gifts, thank yous, free gift cards, free items or services, again, refer a friend programs, any type of marketing campaign that you're out there paying people in order to induce referrals to your organization. You need to look very carefully, especially if it's going to induce referrals for items or services payable by federal or state health care programs. Remember also that this not only applies to you who are paying this, but it also applies to you if you're receiving this. So if you have pharmaceutical device manufacturer representatives coming in or other entities that are coming in, other vendors, and they are offering you gifts or freebies in order to get your business, then the red flags ought to be going up and you ought to be looking at those situations. The risks increase if you're dealing with remuneration with referring providers, because that triggers not only the anti-kickback statute or potentially the anti-kickback statute, CMPL, ECRA, but also STARK. STARK, of course, only applies to referrals from physicians, but if you're dealing with physicians, you got to be concerned with STARK. STARK says that a physician may not refer designated health services that are payable by Medicare or Medicaid to an entity with which the physician or the physician's family member has a financial relationship unless that arrangement fits within a regulatory exception. In addition, most states also have similar laws that would also apply to financial relationships with physicians or other healthcare providers. They may appear in the Medicaid fraud statutes as anti-kickback statutes. They may appear in the Medical Practices Act, like fee splitting or anti-rebating statutes or similar statutes. What are some of the risks in these financial relationships with these referring providers? Well, again, anytime you're giving them any type of remuneration, especially if you're dealing with physicians, you got to be concerned. Those could be gifts like thank you cards. Every year you send out your your gift card or your free movie tickets or a bottle of wine to those referring providers. If they're referring designated health services or other items or services payable by federal health care programs, then there's a good chance that could create some issues for you. Professional courtesies could create some problems, offering them discounts, referral reward programs, fee splitting, practice subsidies, offering, for example, to pay for their malpractice insurance or provide free equipment or free service administrative support. Investment opportunities, so allowing referring providers to invest and they're not paying fair market value and they're kind of getting a sweetheart deal that's not commercially reasonable. That could create an issue. Failure to recoup amounts owed, where a physician owes you money but simply doesn't get around to paying you and you don't do anything about it, then that could trigger it. The Stark Law, if you're dealing with physicians, has a number of potential safe harbors that could apply to these financial relationships with physicians. If you do have any kind of remuneration that are going to referring physicians, you need to look at the Stark Law, see if you can structure that arrangement to fit with any of the safe harbors that appear in 411, usually 0.357. Now, remember that I think in October that the government issued proposed Stark rule changes that would modify the safe harbors and add a few that were more beneficial. We don't know whether those are going to come out. We think that they probably will. I don't have a timing on that, but monitor that because that may loosen up a little bit some of the Stark Law issues and allow you to do some things with referring physicians that you haven't been able to do in the past, including things like value-based purchasing programs and things like that. All right, number 9. So let's move from talking about general remuneration of gifts and those types of things to referring providers. What about contracts with referring providers? Well, presumably the physician is going to get something of value through those contracts, and therefore it's going to trigger the anti-kickback statute, Stark, maybe the civil monetary penalties law, because violations of the anti-kickback statute and Stark are also violations of the civil monetary penalties law. It could hit you up with ECRA and different state laws. What are some of the red flag situations in your contracts with providers? Well, you as compliance professionals, you'd ought to, at this beginning of the year, it'd be a good time to sit down and look at your existing provider contracts to make sure that they fit within the regulations. Some of the red flags are if there is no agreement. You can't find the agreement, particularly if you're dealing with independent contractors. Look at the compensation. Is the compensation fair market value? Was it set in advance or was it based on the volume or value of referrals? Generally, to fit within the safe harbors, you can't pay based on the volume or value of referrals. Now that may be disguised or you may not recognize it, but it could be a share of profit situation. If you're giving this physician a share of the overall profits, then hey, they have an incentive to make referrals. They're getting not only the services they personally perform, but share of the ancillary services and the other things that others are doing that can cause the arrangement to fall out of a relevant safe harbor. Maybe it's you've got a contract for services, but you really don't need the items or services. In that case, you're just trying to float the money. It's a sham arrangement that you're just trying to get money to them, but so you want to pay them. They've got this apparent contract, but it's for items or services you really don't need. Or maybe you're paying them for services that are not performed. Maybe you had a legitimate contract initially, but that physician just stopped performing. And in that situation, if you continue to pay, well, then you're not paying fair market value for the services you're actually getting. Maybe the items or services don't match the contract, especially if it's been in place for a long time. The performance tends to morph over time. You need to periodically look at it and say, okay, is this contract still accurate? Are they still providing the services for which they're paying? If not, then maybe we need to modify it. There are limits under the safe harbors to how often you can modify the contract. For independent contractors, generally you can't modify the contract within 1-year periods. The bottom line there is when it comes to looking at your contracts with your employed physicians, you need to, or your independently contracted physicians, you need to check the relevant safe harbors. Here are the safe harbors. Under Stark, that applies to physicians, it's pretty easy to satisfy the employment safe harbor. Generally, it doesn't have to be a written contract. It doesn't have, the compensation doesn't have to be set in advance. It just has to be commercially reasonable
And you can't pay based on the volume or value of the physician's referrals. You could pay them based on the services they personally perform, but you can't pay them based on the services like the ancillary services that they refer to you, or the services, the incident to services or other services that are billed. Anti-kickback statute's even broader. As long as it's a bona fide employment arrangement, you've got a lot of flexibility there. When it comes to independent contractors, however, the requirements are a lot more specific. You generally have to have a written contract that's got to specify the compensation and the services that are being provided. That compensation formula, if it's a physician, has to be set in advance, has to be consistent with fair market value, and it can't take into account the volume or value of services or other business generated by the physician. The arrangement has to be commercially reasonable and further a legitimate business purpose, and the compensation or other key price terms can't be changed within that 1 year period. The anti-kickback statute has similar requirements, only it actually requires that the aggregate compensation be set in advance. The OIG has proposed a regulation that would modify that to more closely align with Stark, but we don't know exactly when that's going to come down yet. So the bottom line is, for independent contractors, your medical directors, any services contract that these referring providers are providing for you, you need to take a look at these contracts and make sure that they have been structured to fit within one of these regulatory safe harbors. Well, what about you who are just physician groups? Well, if you're physician groups, there's a separate exception that applies to, or potentially applies to, payments that are made to members of the physician group. And in order to do that, you've got to satisfy certain criteria. Generally, when it comes to physician group compensation or structures, those physicians are making referrals within the entity, so it's going to trigger Stark. So then the question is, okay, we got a Stark safe harbor. If you're operating in a rural area and you can fit within the rural provider exception, that makes it pretty easy. If you are, however, in a metropolitan statistical area, then you generally need to rely on the physician services or in-office ancillary services exceptions. Generally, both of those require that you qualify as a group practice under Stark in order to get the benefit of those exceptions that allow referrals within the group. Now, in order to be a group practice, though, you have to satisfy the group practice definition under Stark. It has a long list of criteria that you have to satisfy. Those criteria are basically designed to confirm that this group is really functioning as a group. It's not just a bunch of separate practices that call themselves a group so that they can make referrals to each other. Instead, it has to be functioning as a physician group with centralized decision-making, generally operating as a single legal entity. Most of the group members have to be providing services through that group, not just through all these collateral entities. And the one that trips up most groups out there is the compensation formula. Generally, to fit within the group practice definition and therefore satisfy Stark for group practice referrals, the compensation formula for the group members has to be set in advance. You can't do it after the fact. Pure eat what you kill, including items or services you order but were performed by others, are problematic. Generally, you can't pay based on services. You can pay based on personal productivity, services you personally perform. You can also, under the group practice exceptions, pay for a physician can get part of the incident to services that are billed pursuant to that physician, but you generally can't give them productivity credit for services that are performed by others or ancillary services they order. Well, could you just share in overall profits? Yeah, you can, but in order to share in overall profits, you can't have a group of less than 5 physicians, this subgroup of less than 5 physicians. Of course, unless all you have are 1, 2, 3, or 4 physicians or 5 physicians, then all of those 5 physicians can share in it. But you can't just say, this physician, we're going to treat him as a different cost center or profit center, so he's going to get all the revenue from the services that he orders or refers. That would cause you to probably fall out of the group practice exceptions and then create Stark issues for intra-group referrals. Space or equipment leases. That can also impact Stark anti-kickback statute if you are allowing others, referring providers, to use your space or equipment for free. In those situations, you generally need to make sure that you structure your deal to fit within one of the regulatory safe harbors. In addition, if you're a hospital, it can also, allowing the other to use space or equipment could potentially implicate Medicare requirements such as co-location in the hospital or provider-based billing if you're leasing out or allowing these physicians to use this stuff on an exclusive basis. Some of the red flag areas for these kinds of use of space or equipment are free or discounted use of space or equipment, free supplies that go along with that, that physicians using some space, maybe you're leasing some space to them, but they go in there and take stuff off the shelf and use their supplies. Maybe free support services. They're not paying for the receptionist or the janitorial service or other things that you may be providing. Maybe free storage. They're leaving their stuff in there, but they're not paying for the storage. There is no written lease or timeshare agreement that would justify it. Maybe it's shared space or equipment. Generally, in order to fit within the safe harbor, the physician has to have exclusive use of that space. We'll talk briefly about that in just a second. Maybe it's not distinct from the hospital space, so it's part of the hospital. That could create some issues when it comes to your provider-based rule compliance. Maybe the overall arrangement is not commercially reasonable. Maybe you're undercharging them, or perhaps for that particular item or service. Maybe that physician is using the wrong side of service modifier. You're allowing that physician to come in and use your stuff, your space. You intend to charge a facility fee, but that physician is charging a site of service modifier that indicates that it's in his own practice. So he's getting a higher reimbursement as if he's doing it in his own practice space when he really doesn't have the cost associated with it because he's using your space. If he's using that wrong site of service modifier, then that can create problems. Again, you're going to want to structure any kinds of these lease or use of space or equipment arrangements to fit within one of the Stark lease safe harbor and the anti-kickback safe harbor. They also have a new one applicable to timeshare arrangements, which is helpful if you want to share the space or equipment, but there's a lot of criteria that have to be satisfied for that one. All right. Leaving the fraud and abuse issues, let's talk briefly about telehealth. That's it. Everybody's getting into the telehealth market, but just make sure that as they're doing that, as your people are doing that they're realizing the compliance issues that may be going along that they may not realize. For example, if you may have a situation where that telehealth provider is in another state. Well, if they're reaching out and providing telehealth services in your community, in the site where the patient is located, then the general rule in most states is that telehealth provider has to be licensed in your state. If they're not licensed in your state, that could certainly cause them problems, but it can also cause you problems if you're seeking reimbursement, because generally your Medicare or Medicaid will only pay for services that are provided by a licensed provider. You may have problems if you haven't credentialed those providers. Generally, Medicare conditions of participation require hospitals and other entities to credential those who are providing services at the hospital, which would include telehealth providers. Now, the government has come out with regulations that would allow you to credential them by proxy, but they have certain requirements that you have to satisfy in order to be able to credential by proxy. So you'd want to make sure that you're complying with that. Take a look at, okay, what telemedicine programs are out there? Have these people been properly credentialed? Maybe you have a situation where you're doing this telemedicine. It could create unintended patient relationships where you thought you were just doing a curbside consult and the patient suddenly thinks that, hey, you're his physician. And if you fail to provide services, that could result in malpractice claims or perhaps patient abandonment. Maybe you're not getting sufficient consent, either because you're not explaining the limitations or that you are providing the services through telemedicine, or you're not complying with specific statutes. A lot of states have their own telemedicine statutes that require certain types of information to be provided as part of informed consent. You may have insecure communications or unsecure communications where you're not complying with the HIPAA security rule, or otherwise you're communicating via unsecured or unencrypted email or other methods. Maybe you don't have any insurance coverage. You thought that you had coverage for state aid, but once you begin providing insurance coverage into, or excuse me, begin providing telemedicine services into state B. Maybe your insurance doesn't extend over there, so you're going to want to check and make sure that there's insurance available for that telemedicine coverage. You're going to want to make sure that you maintain adequate documentation. Sometimes it's hard. If you're providing those services through telemedicine, maybe those notes or that recording doesn't get into the medical record. You need to come up with a process and look to make sure that that stuff's getting into the medical record so that you've got the documentation you need. Finally, when it comes to submitting the claims for telemedicine services, payers, including Medicare and Medicaid, have requirements in order to that must be satisfied in order to allow you to bill for those telemedicine services. Make sure that you're complying with those requirements. Next, marketing programs. We've already covered a lot of these concerns in the stuff that we've talked about already, but I wanted to throw in this additional slide because I really do want to emphasize that the compliance people need to work with the marketing people. The marketing people, they came out of school and they suddenly get into this healthcare field and they have no idea that these fraud and abuse laws and these other laws apply to them. So the compliance folks really need to work closely to ensure that the marketing programs for your entity are consistent with the applicable laws, including beware of any kind of patient inducements, especially involving federal healthcare program beneficiaries, referral rewards like commission-based compensation, or paying for referrals versus paying for leads. If you're a facility, a hospital, you may need to be careful about advertising in independent physicians' private practice or otherwise subsidizing their practice expenses, including advertising expenses. Beware of HIPAA, using or disclosing protected health information without authorization. Generally, you can use patient's protected health information if you haven't agreed otherwise with the patient. You can use it to market your own products or services, but not the products or services of another entity. And you can't even use it to market your own products and services if you're getting paid by another entity in order to make that marketing communication. Beware of social media situations. It's really easy for patient photographs, for patient testimonials and things like that to suddenly appear on the website when you haven't got the patient authorization to do that. Beware of false or deceptive advertising, white coat marketing, which is when you're using a healthcare professional to give a testimonial or advice, and the FTC has suggested that that may be deceptive. Be careful of those situations because it could create this false sense of security in that professional that's really not justified. So beware of those situations. The FTC has other rules for testimonials and endorsements. Telemarketing, if you're using telemarketing and using robocalls, then you have to make sure that you comply with the Telephone Consumer Protection Act or the TCPA. Certain types of government programs may have limits on the way that you market their product, including for DME, that there's limits on making direct contact with program beneficiaries. Make sure you're aware of all of those things. All right, you knew you weren't going to get out of here without talking about some HIPAA stuff. So first, your HIPAA security risk assessment. We already mentioned this. It's key to doing cybersecurity, but even if that wasn't enough, HIPAA requires you to do a periodic risk assessment. They haven't told you how often you should do it, but certainly on an annual basis would appear to be reasonable. You've got to conduct an accurate and thorough assessment of your potential risks and vulnerabilities. That includes things like cyber threats, your software. If you got the appropriate software in place to protect or back up your data, if you got firewalls in place, if you got other types of protections. What about your hardware? Where is your hardware? Where's it going? Has it been wiped before it's disposed of? Where are the potential leaks? Mobile devices, that is a huge issue. In fact, it's so huge that the government identified that as one of the 5 factors in that cybersecurity guidance. Beware of mobile devices. Are your mobile devices, do they contain protected health information? If they do, are they encrypted? Encrypted is a assumed standard. So you need addressable standards. So you need to make sure that they're encrypted unless you can come up with another alternative that provides the same level of protection. That's awfully hard to do. What about your emails and texts? Are they encrypted? If not, then you probably have problems. Are you using secure networks? Or what about social media? What about the disposition and destruction items that have data on it. Maybe it's your copier, maybe it's recycled computers. Are they adequately or appropriately destroyed so all that data is gone? What about vendors? What access do they have to your information? Are they maintaining the safety and the confidentiality of that information? What about employees working off-site? Does that create a leak for you? What about hybrid entities, others in your organization who are not part of your healthcare operations, but they may have access to health information? Have you set up the appropriate hybrid entity? And on and on and on and on. You need to do an appropriate risk assessment and involve your IT people. Fortunately, the government has come out with a security risk assessment tool that if you didn't want to pay a consultant to come in and help you do that and pay $20,000 or so per pop, you can go and use this security risk assessment tool. It's for free on the government's website. They updated that recently, but I can't emphasize the importance enough of the security risk assessment. One is for the cybersecurity things like we talked about. Two is, and when you look at a lot of the recent six-figure or seven-figure OCR penalties that have been coming down, almost all of them involve some situation where they didn't do an adequate risk assessment, and that resulted in the breach. Next, make sure that you've got appropriate HIPAA business associate agreements in place. If you're paying or contracting with somebody to do something for you involving protected health information, they're probably going to be your business associate, and you need to make sure that you have a business associate agreement in place. Go through and look who has your information and determine whether or not they're a business associate that you need to have the agreement in place. It would be your any vendors with access to PHI, data storage companies, cloud service providers. If you're storing stuff out there on the cloud, your cloud service provider generally is going to be a business associate. You need to get a business associate agreement in place with them. Your document destruction company, your managers, billing companies, coding companies, auditors, consultants, accountants, lawyers, if they're getting protected health information, collection agencies, answering services, transcription services, interpreters, marketing or public relations firm, third-party administrators for your employee benefits plan. Remember, HIPAA applies to your employee benefits plan just like providers. Accreditation organization, medical directors, other entities that are providing administrative services on your behalf. Make sure that you go through your list and make sure that you've got business associate agreements with these entities. If you don't, recently the government has been tagging people holding the covered entity responsible for their business associates' violations of HIPAA if there was no business associate agreement in place. HIPAA breach notification. If you have had a breach, then the HIPAA rules generally require you to give that breach notification. That notice has to be given to the affected individuals no later than 60 days after it's discovered by anyone in your organization, not counting the person who actually committed the breach. In addition, you also have to give the notice to HHS. The only difference is the timing of it. If the breach involves 500 or less persons, then you can wait and do that breach notification within 60 days after the end of the calendar year. So we're in that 60-day window right now for breaches that occurred in 2019. You'd have to file that by, I think, let's see, this is a leap year, so by March 1st, 2020. If the breach involves more than 500 persons, you generally have to give that notice at the same time you give the notice to HHS, at the same time you give the notice to the individuals. What are the risks for those breaches? Well, a breach is the acquisition, access, use, or disclosure of protected health information in a manner not permitted by the privacy rule, which compromises the security or privacy of the protected health information unless you can establish that there's a low probability that the data has been compromised. So if you have the unauthorized access, use, or disclosure that violates the privacy rule, it's presumed to be a reportable breach unless you can prove that there's a low probability that data has been compromised based on those risk factors. Now, you have to be careful about the failure to report a breach. The breach is because of the increased penalties. In general, under HIPAA, if you do not act with willful neglect and you correct the situation within 30 days, then that is an affirmative defense to HIPAA penalties. On the other hand, if you act with willful neglect, you get hit up with mandatory penalties of at least $20,000 to $57,000 per violation. Now, that mandatory penalty, the concerns about that is the government has said, if you fail to report a breach because you're afraid of the adverse publicity or the like, then that's willful neglect and we'll have to impose those mandatory penalties. So you may have a situation where the initial breach was not done with willful neglect, but if you fail to report the breach, then that could be willful neglect and it could result in a penalty. So in a closed case, you almost always want to do the breach report. Next HIPAA issue. The government has, you've probably seen some of the settlements come out. The government's kind of on this kick about the patient's right to access. So make sure that you're complying with the rules concerning the patient's right to access. In general, the patient or the personal representative have a right to access protected health information that's maintained in their designated record set with very limited exceptions. The OCR published this guide a few years ago on individuals' rights under HIPAA to access their health information. If you have not read that, you really do need to read that because it is a really good guide and helps you get where the government's coming from when it comes to this right to access. In some ways, I think they actually expanded the rule and put more burden on the covered entities, but you need to be aware of what those requirements are. Some of the risks that you need to be aware of. Have you got an appropriate process for handling requests for information, not only for the patient's own access to the information, but if the patient asks you to send their records someplace else, that's part of their rights, under the right of access, they can do that. Is there an unwarranted denial of access? Maybe because you've got providers who just think the patient shouldn't have the information. Well, that's not really good enough. Are you limiting the information that's provided unilaterally? For example, you're not providing information that was sent to you by another healthcare provider. Well, if that's in the designated record set, the patient has a right to access it. It doesn't matter who created it. Are you not sending the records as requested? Did they request it in a certain form or format and you didn't send it? Are you not doing it on a timely basis under the rules, or are you charging too much for copies? So you might want to take a look at that. Next, you may want to review your HIPAA forms and HIPAA forms and documentation. A lot of these HIPAA forms were created back in 2003 or 2005 when the privacy or security rule came out, and then they've just been in place forever and nobody's ever looked at them again. Or over time, they have a tendency to morph where additional stuff gets put into your authorization or into your notice of privacy practices, and the first thing you know, they no longer contain the terms that are required by HIPAA or that are consistent with what you are actually doing in your particular organization. So it's probably a good idea, if you haven't done it recently, to sit down and actually look at your HIPAA required forms, like your authorization form. Does it contain the required elements in 164.508? Your notice of privacy practices, does it contain the required elements in 164.520? Your business associate agreements, do they contain the proper elements, the required elements as set forth in 164.314 and .504E? Other types of things. Are you maintaining documentation you need, like your accounting of disclosure logs or your breach notification records, things like that? Were your records created, your forms been updated since 2013 when they came out with the omnibus rule that required updates? If not, then you need to update those forms. All right, that kind of wraps up kind of the HIPAA stuff. Of course, make sure that your people are aware of breaches and the privacy rules too. Next is non-discrimination. We were silent on this for quite a while. Remember under the Affordable Care Act when that first came out, they came out with Section 1557, which expanded the requirements for healthcare entities, and then President Trump was inaugurated and suddenly everything kind of went silent. The Office for Civil Rights, who's in charge of enforcing this, has been more active over the last few months. You may have seen a few reported decisions coming out. So we may want to turn back to this and make sure that we are complying with these non-discrimination statutes, including the Affordable Care Act, Section 1557. Now, under that 1557, you remember a few years ago when I spent several webinars talking about those notices and the taglines and stuff that you needed to do, as well as the rules concerning gender identification? Well, a lot of that now has been withdrawn or at least suspended. The government has proposed new regulations that would basically withdraw a lot of those notice requirements, and the regulation that came out in the Obama era dealing with gender identification, that has been suspended via an injunction by a federal court. So the bottom line is those kinds of things, I probably wouldn't worry too much about those. Those are probably going to go away at least, but we still need to be concerned and make sure that you've got appropriate policies and procedures in place for handling patients with disabilities, not only the person themselves, but also people, family members and the like who come in with them, who are personal representatives and the like. You need to make sure that you have auxiliary aids that allow you to communicate not only with the patient, but these other persons. Persons with limited English proficiency, that they can't speak English. The general rule is you got to provide interpreters or translations of key documents. Sex discrimination, you've got to provide appropriate physical access to your facilities for those with disabilities. Websites, the ADA has been extended to websites, so you may have an obligation to update your website to make sure that it's ADA compliant. Service animals, there's kind of, a lot of that's going on right now with emotional support animals. Under the ADA, actually, the ADA doesn't extend to those emotional support animals. It only applies to service animals, which are dogs and, oddly enough, miniature horses. But some states have broader laws than the ADA, so make sure you're aware of that and have existing policies in place for those non-discrimination situations. All right. Those are kind of the laws and stuff you need to be concerned about. The number 19 on my list of things for you compliance officers to do is take a look at your compliance plans. That's probably been in place for a long time, but maybe it's time to dust them off and see whether they're really working for you. The government has said that providers should regularly review the implementation and execution of their compliance program elements. The ACA, the Affordable Care Act, actually requires that healthcare providers, including hospitals and the like, to put in place compliance plans, but we haven't got the final rules on that yet, so it's kind of in there, but not really. Long-term care facilities do have the final rules. They've got to have their compliance plan in place. The rest of us, we're kind of waiting for those final rules. In the meantime, however, we want to have an effective compliance plan because that will help mitigate it will help ensure compliance, but it'll help mitigate damages if the government comes in after us. The elements, the 7 elements identified by the OIG in their compliance program guidance includes internal auditing and monitoring, compliance program standards that are advertised and published to your personnel, having a designated compliance officer, providing appropriate training for your personnel concerning compliance issues, make sure you've got an effective way to respond to compliance issues when they come up, that you maintain open lines of communication, whether that's a black box or an anonymous 1-800 number that people can call, and of course enforcing compliance, that you follow up if there's compliance concerns that are raised. It's probably a good time, if you haven't recently, again, to go back through those compliance program guidance that I gave you the sites to, that have been published by the OIG, and look at those and evaluate, okay, how's our compliance plan working? Have our operations changed? Do we need to modify that compliance plan? All right, and number 20, the last one, is to make sure you do your compliance training. Compliance training is kind of like your vaccination or your inoculation for compliance issues. Again, one, effective compliance training may help your people actually comply. Two, even if it doesn't, it can help protect you from penalties if the government comes in against you. Maybe not so much on the OIG with the fraud and abuse issues, but under HIPAA, they've specifically said that, look, if you've done everything you can, you provided the training, you had the policies and procedures in place, and you just have a rogue employee that goes out and messes up, well, that may not be willful neglect for you. It may be willful neglect for that employee, but we're not going to come back and hit you up with it. And therefore, so long as you correct the situation within 30 days, you can avoid fines or penalties. Documenting that training is critical to showing that you're not acting with willful neglect. If that's not enough, the rule specifically says that under HIPAA, you've got an obligation to provide periodic privacy and security training for your workforce members. For fraud and abuse and other issues, the OIG is a little bit more general. The guidance, at least for hospitals, is that you should conduct annual training to ensure that each employee, contractor, or any other individual that functions on behalf of the hospital is fully capable of executing his or her role in compliance with the rules, standards, and regulations. So make sure that you provide the relevant training, including fraud and abuse issues like we've talked about that are relevant to that employee's role, coding and billing issues, payments for referrals, HIPAA, your compliance plan, your policies, reporting and responding to noncompliance, and of course, as you go along and new things come up, make sure that you're periodically updating them, providing ongoing training for new events. Make sure you document that training, have them sign something, and it's probably a good idea to have the patient, or excuse me, have the employee or workforce member or contractor agree to comply. Have them sign some kind of acknowledgement that they agree to be bound by it and that they will comply. Make sure that you yourself stay informed concerning the compliance issues that come along. So to that end, you ought to consider signing up for some kind of a listserv. We provide periodic client alerts. If you're not receiving those and would like to receive those, just shoot me an email and we'll add you to our list. There's no charge or anything. It's free, but we provide those kinds of client alerts for clients. Additional resources that are out there. The OIG has a very helpful compliance website that has videos talking about this stuff. You can use them in your training as well as to learn the stuff yourself. The OIG's got other publications, especially those compliance program guidance that I've harped on ad nauseum. We also have a bunch of compliance resources on our website that are free, including webinar materials covering a lot of the things I've talked about today in more depth. We also do those free client alerts. Again, if you'd like to participate in those, just let us know. And finally, just wanted to tout that on an annual basis, we do a compliance boot camp. Our next compliance boot camp is coming up February 28th. It's actually going to be here in Boise, but we are going to broadcast that out. We will be covering things like fraud and abuse laws, HIPAA, informed consent, terminating patient relationships, and so forth. If you would like to participate in that, again, there's no cost. Just let us know. You can sign up, and it's a little free training for you. It will be here in Idaho, so we will focus somewhat on Idaho, but because most of these laws are federal by nature, they apply across the board. That is it. That is my top 20 list of things that compliance personnel need to do for 2020. I hope that's helpful. If you have any questions, by all means, feel free to shoot me an email, or you can submit questions using that chat feature, and I will respond as I can offline. Thanks much, and hope you have a good week.